Well, when I come on your show, I try to get some of the better ones from the month, some of the ones where the non-citizen has some sort of a victory. And the two prominent ones from the last month are both from the BIA, which I could not have said for the last prior administration. I could never have told you that there were two positive. Seriously, I think there was like one or two in 4 years, and certainly not two in a month. But there are, and they're both in the crimmigration realm. And the first is matter of Dingus. Oh, of course, I talked about all these in depth on the podcast, and so I don't do that here. But matter of Dingus is about what happens when a conviction gets changed. In this case, Miss Dingus from the United Kingdom actually had a conviction for essentially distributing or dealing in meth, I believe. I believe it was methamphetamine. Either way, it was a bad drug. And eventually in Virginia, the conviction was amended and to say that she was distributing Salvinorin A, which nobody seems to know what it is, but that is what she was convicted of doing it. And the court did it non pro tunc, which means from the beginning, which essentially means that she never had the conviction for distributing methamphetamine or whatever else it was. It was Salvinorin A from the beginning. And that's important because Salvinorin A is not federally controlled, which means that her conviction is not a controlled substance offense. It's not a drug trafficking aggravated felony because Salvinorin A is not controlled. And this whole decision by the board was about, well, originally it was for methamphetamine. Do we give credit to this change? And the board said yes. And in doing so, the board solidified the more difficult for non-citizen case law of matter of Thomas and Thompson, matter of Pickering. Matter of Thomas and Thompson was Attorney General Barr's big decision 3 years ago, where they said all these other BIA decisions about what happens with amended convictions, I don't care about them. They're not good law anymore. Only matter of Pickering does. And that means that you only give credit to an amended or vacated sentence if it was done substantively or for procedural, for something that makes the conviction itself invalid. But if it was done for rehabilitative purposes or for purely immigration purposes, then the immigration courts aren't going to give it effect. Even if a state is saying we don't recognize this person as having a conviction anymore, unless it's done for the right reasons, Pickering and Thomas and Thompson say we don't care. And in matter of Dingus, they said this is one of the ones that actually we do care. A non-pro-tunc order, at least in Virginia. And the board is saying that it does require a analysis of how the state treats, in this case, non-pro-tunc changes. But this is one of those cases. This is a substantive change based on what the conviction should have been. And that's going to count. And it meant all the difference for Ms. Dingus's removability and her eligibility for immigration relief. So, it's a great case to see if you're working in the world of crimmigration. I don't love how it implicitly solidifies matter of Thomas and Thompson, which I don't believe was necessarily required. Attorney General Barr decided to vacate 3 published BIA decisions in Thomas and Thompson. Attorney General Garland could agree with the Board of Immigration Appeals and say that actually there are all these other rules, but he hasn't yet. Either way, a little breathing room for amending convictions and a path forward for non-citizens who need their convictions amended based on, for example, some substantive flaw in the original conviction.
What a game changer for that person, Dingus, the foreign national in this case. So they had the money to hire a lawyer to undo the original criminal court case, and then they had the lawyer and the money and the time to do a BIA appeal, and it worked.
Well, that's the unwritten part of it. And if you think that's crazy, wait till I get to the next case, matter of Dang. But no, that's right. That's the terrible part of this is so much of this good law that I like to talk about in all of the cases almost I talk about on the podcast are at the circuit level, and it costs a fortune to get to the circuit, and it necessarily means that you've lost twice.
Yeah.
So it really is how many Miss Dinguses, how many other non-citizens are out there who just didn't have the money to get to the circuit and to get a decision about how the law is supposed to be.